And guys, this is just the beginning, because I'm staring at least 7 more documents from Amro Elansari here, so we are not done. So join me as we continue down this rabbit hole.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Let's go backwards and start at the beginning. This is what started a very long, or a large number of Amro Elansari's filings. He has filed this lawsuit against an apartment complex, and he says, the American flag has been taken. The broken English maintenance workers told by their English-speaking supervisor to tear down a political and religious free speech representation in protest of their unlawful discrimination of the plaintiff. But the error that would come from this incident would not be the only type in this case of corruption, discrimination, and injustice. Not only is the housing organization being called to responsibility in this case, but the numerous judicial officials who have engaged in a very specific and systematic conspiracy to circumvent due process, the Constitution, justice, accountability, and responsibility in the form of a carefully planned form of institutional racism and discrimination which is unlawful. And the interrelated actions of the remaining defendants are all intertwined in this complex system of unlawful institutional racism, are all incorporated in this case through the doctrine of supplemental jurisdiction. This is a case about the American flag that has been taken. Amro Elansari, the lead plaintiff and victim of each of one of the following defendants' actions, Golf Club Apartments of West Goshen, Pennsylvania, lured the plaintiff into an uninhabitable studio apartment for $1,100 a month and a $500 transfer fee, and they increased the fee to $1,000, which was a breach of contract. Then they canceled the plaintiff's transfer when he said he would pay the fee in retaliation to his opposition to the fee and other breach of contract. Furthermore, they unlawfully converted property from the plaintiff, including political speech and the American flag, and initiated eviction procedures despite their initial promise of apartment unit F24 being where the plaintiff was being transferred to. The reason the plaintiff was transferring was due to numerous disturbances by the neighbors in the form of banging on the door because of a medical cannabis odor that never really existed, which is technically discrimination based on medical condition in housing as well. Ms. Lippincott, a fraudulent and corrupt conspirator in judicial scheme known as the senior judge shuffle, where a senior judge comes into a case and rules absurdly, offensively, discriminatory, and legally incorrectly, knowing that they bear no responsibility to the electorate. Despite the PHRA and housing discrimination affirmative defenses raised, Lippincott, with the prejudicial and intentionally tortious attitude, nonchalantly found against the plaintiff and made him to appeal a $3,000 judgment for an uninhabitable hostile apartment the plaintiff was supposed to move out of in the first place. William Kraut, corrupted and fraudulent judge in West Goshen Township, conspired with Lippincott to perform the institutionally prejudicial and racist tactic known as the senior judge shuffle to specifically deprive the plaintiff of the due process of law and open access to the court system. Robert Schenken, senior judge assigned to a civil lawsuit the plaintiff filed in equity to either open up the apartment promised or prevent the unlawful eviction until the matter was decided upon the equity without the requirement of a fee for an uninhabitable apartment that the plaintiff never agreed to stay in beyond the month of June. Ignored. Slenkin continued to recommend the Bar Association that the plaintiff went to and was referred to, some of the most atrociously incompetent attorneys, one of which promised to help the plaintiff in their eviction case and then reneged on his promise as the events unfolded. This attorney was Mark Cronin, thereby completely depriving the plaintiff of the opportunity to be heard, as they are entitled to uncover the procedures of law. The following days, as the plaintiff is fighting nonstop to prevent the impending unlawful eviction, Judge Griffith grants Golf Club Apartments 10 days to respond to the petition and prevent the eviction. As the days towards the eviction impend, no decision is made and the time for eviction imminently comes. The 10 days was completely insensitive to the situation and instead an institutionally racist and disrespectful tactic to cause plaintiff serious bodily harm in the form of an unlawful eviction. Mark L. Tunnel, also in on the conspiracy, is another judge that denied an emergency petition and a hearing on the petition in the imminent amount of time of the eviction as possible, and is also a party to this entire act of institutional racism depriving a person of the due process of law. Considering their case guaranteed with the passage of the new medical cannabis law, the plaintiff went to the Superior Court of Pennsylvania to appeal this completely unfair series of events. To no event. By the way, has anyone figured out what series of events? He got evicted? There was a hearing? And he lost? Is that really the series of events? I can't make out the details of anything in there that, like, gives rise to any sort of legal claim. Like, my judge was corrupt. Doesn't tell me anything. That doesn't do it for me, right?
Well, it's that shuffle. The senior judge shuffle. The shuffle.
I'm so confused.
Yeah, I'm a bit confused myself. It's plausible. I could see a senior judge shuffle. I could see, but no. What he's calling the senior judge shuffle is actually half true. Senior judges do come back and serve time before they fully retire. Senior judge sometimes doesn't mean the judge has seniority in authority. It sometimes just means they're an older retired judge that will help out where needed. To no avail, a careless, disrespectful, dismissive judgment was issued in complete disregard to the situation and the rights of the plaintiff in that matter. But this is not the first time the Superior Court has completely disregarded the arguments of the plaintiff. It is actually the third. There are also 2 other cases in which the Superior Court, disregarding the constitutional law principles argued for, took the completely serious issues raised and barred them from consideration due to the simplest structuring matter in the brief, addressing rational basis as one subtopic and strict scrutiny as one subtopic instead of addressing the issue of constitutionality as a whole. Addressing basic scrutiny and then strict scrutiny separately is the proper way to do it. Led by Jack Piniella, another senior judge, and William H. Platt and Annie Lazarus, as well as Susan Gantman, all commit the institutionally racist practice of pointing to such a little procedural matter such as the categorization of subcategories in a brief to allow for tremendous injustices and violations of due process to take place, as well as barring the plaintiff from the opportunity to be represented as they are entitled to under the due process of law. This is complete and utter institutional racism at its very clearly identifiable core, and all these individuals are called to responsibility. A life pro tip: if you're going to call someone racist, point out the racist behavior. Not just, I got pulled over by a police officer, that's racist behavior. No, you have to figure out, find a way to explain why you think you were called out by race. So going back to his Runescape complaint, it does seem plausible that he really does think, remember I said 14th Amendment, protected class, that he really does think that Runescape muting him was because of his race. I don't even know what his race is. I don't know what his premises or what his logical proof is for how this is race related, which is just weird. Which is weird. This whole thing's weird. Members of the Superior Court of Pennsylvania, who time and time again have barred the plaintiff from open access to the courts. In other words, they're familiar with him. He's done this to the Superior Court of Pennsylvania as well. Who time and time again have barred the plaintiff from open access to the courts, are also implicated in a system of corruption and institutional racism. There's scandals such as the pornography scandals and allowance of Pennsylvania to have the single most corrupt judicial system is a critical detriment to the integrity of law. No citations to most corrupt legal system. Sure, I'll buy it. Sure, there could be corruption. We had the Cash for Kids case in Luzerne County, and then there was that, wasn't the meowing judge in, no, that was Ohio. That was in Wisconsin. But there was somebody recently in Pennsylvania, though. We just went over somebody in Pennsylvania, I thought. But yeah, so there's been corruption, sure. I don't know if it's the biggest, most corruption in the nation, though. I don't know about that one.
So where can I hand in my pupils for cash?
Oh yes, here we go. Thomas Kistler, former judge in Center County, Pamela Rust, etc., etc. Stacy Parks Miller. Remember Stacy Parks Miller? She was the now, I think, suspended or disbarred attorney from Center County. She was their district attorney, I believe, and she had improper communication with a judge and improper setting up of a Facebook sting operation. Like, no, you have to go through certain channels to properly set up a sting operation, and they didn't. So it was actually in violation of her being an opposing party. You can't be an opposing party, the prosecutor, and also be the one conducting the sting operation. So she was misrepresenting her role as a prosecutor in violation of her ethical duties. Are all parties to the case for refusing the plaintiff the opportunity to speak constituting deprivation of rights under the color of the law? Jake Corman, their fuel. No, really, it says that. Like, literally says Jake Corman, their fuel. Probation officer in Center County, Ashley Delker, is party to this case, having specifically acted in a way to harm the plaintiff by causing his incarceration for an additional 3 months to think about how much marijuana has brought the plaintiff back when she knew that he had a medical condition prescribed by law. He was apparently arrested for something related to cannabis. Not sure why he would get 3 months for that.
Basically,
Usually there would have to be something more than just possession for that.
to add to that, like, that's when he was at law school and apparently had an altercation with the police and light up and joined right in front of them because he wanted them to arrest him so he could take them to court and try to get marijuana to become legal.
This person's a law student?
He got kicked out of law school.
Good.
And I'm pretty sure he also tried to sue his law school for kicking him out of law school.
Oh, well, I don't know that we have that one. I do have a Pennsylvania state education lawsuit. We'll see about that. The members of the Pennsylvania Supreme Court who are too busy looking up pornography on their computers instead of science and news regarding the legalization of pot nationwide due to its medicinal use are all parties to this case, and then it names all these, for their combined institutional racism and obstruction of justice, as well as fair and open access to the justice system, resulting in damage to the integrity of the law. Others are included for their damage to the integrity of law and a review of all actions stemming from this corrupt judicial system for civil rights violations caused by these people is requested. Let's see, I'm going to start skimming a little bit here because there's some really good stuff towards the end, and this is 65 pages long. Dell Inc. is included in the litigation for its role in a bait-and-switch scheme implemented by Best Buy, as well as the sale of a defective product to the plaintiff that gave rise to the litigations in Philadelphia, resulting in institutional racism, unlawfully barring the plaintiff from justice and open access to the courts. Well, there's a wonderful opportunity to explain to you what proximate cause is. You have two kinds of cause required for a judge to find you are damaged by someone and therefore owed some kind of remedy. The but-for cause means that there had to be a factual cause that started it all. You're driving down the highway, a mile in front of you, somebody takes their eyes off the road and negligently causes a motor vehicle collision. It shuts down the highway for 5 hours. You were on your way to an interview, you don't make your interview, and you don't get the job. The motor vehicle collision caused by that person's negligent act is most definitely the but-for cause of your missing your interview and not getting a lucrative job. But you cannot successfully sue the person who caused the motor vehicle collision negligently because of the doctrine of proximate cause, which basically says that there is some limit to how connected causes have to be, and we will cut it off after basically like 1, maybe 2 connections. There has to then be some legal connection continuing the proximate cause and continuing the claim, enabling the claim. So in other words, Congress would have to make a law that says that if you're delayed by a motor vehicle collision, you have a civil claim against the person who caused the motor vehicle collision. Right now, as the courts say it, the courts would say that there is not proximate cause between the motor vehicle collision and you being late to work. There might be but-for cause, but because you could have called work and they could have understood and all that, this is not something that is foreseeable by as a result of a person being negligently on their phone causing a motor vehicle collision, that somebody a mile back is going to suddenly have a claim because they missed their job interview. That's not foreseeable enough. So that's what that's about. And yeah, if Dell and Best Buy sold a defective product, sure, they have some kind. This person, Amro Elansari, has some kind of claim against Best Buy or Dell. Not whatever this is. This lawsuit was against like everybody else. I guess it is Golf Club Apartments et al. So maybe that's the et al. Part. So Best Buy is included for their bait and switch tactic. Dell is included. We saw that. More Best Buy defendants for the same violation. More deprivation of constitutional rights. Apparently, they exposed him to fluorescent lighting for 24 hours a day, months at a time, which is also a dangerously insufficient diet and dangerous conditions at his correctional facility. So in other words, he didn't like being in prison. Thomas L. Ambro for scoffing at the plaintiff in medical need due to their mix categorization and the intake of cannabis through the respiratory system, which is the most common way it is used, constituting institutional racism. Wait. So he's upset that he got to use medical cannabis in prison, but didn't get to inhale it. Really? Tim Savage for unlawful deprivation of plaintiff's constitutional rights. A little bit of foreshadowing here. Remember that name, Timothy J. Savage. Paul Diamond for unlawful deprivation of rights. And then here, the Commonwealth of Pennsylvania and the United States are named as defendants in this case for violations of the 14th Amendment, which is a claim that overrides sovereign immunity. Plus, in handwriting here, plus Supreme Court, John Roberts, Clarence Thomas, Ruth Ginsburg, Stephen Breyer, Samuel Alito, Sonia Sotomayor, Elena Kagan, and Anthony Kennedy. So yes, he just also sued the Supreme Court. As defendants to this litigation, it is hereby respectfully requested that the instant judge, Judge Savage, assigned to this case, recuse themselves from the instant litigation. So he is suing the judge in the case the judge is assigned to? I don't even know how he's done that. I don't even know how you've done that. Notice to defendants, over the past several years, each of you has taken specific steps to deprive me of my constitutional rights, not simply for the issue of pot, correct as it is, but you have specifically taken steps to deprive me of the opportunity to speak, the opportunity to be truthfully and accurately represented, and the full and open access to the due process of law. Your signatures on every paper signed against me constitutes evidence in this regard. Okay. The facts, science, and statistics, such as the ACLU and scholarly reports showing direct racial disparities in the enforcement of pot law. Oh, God, is that it? Is that really it? He's saying that he was racially profiled in the enforcement of pot laws?
Since the word racist was brought up that many times, I decided to have a quick look to see if we could get some clarification. So, Annabelle Smith from Penn State University wrote this article and interviewed him. I'm just gonna quote her directly and cite her and can link to this article. Aside from being slandered, defamed, and having my reputation tarnished for smoking pot, which doesn't cause you to black out, I was forced to live a criminal life that didn't hurt because of a herb that didn't hurt anyone. Good luck, Brandon, with that.
Herb.
Sorry. Blah, blah, blah. I was tired of being treated like a second-class citizen because he's smoking marijuana, and saw this as a violation of our due process and equal protection and the rights of the 14th Amendment. To challenge this, he lit up a big joint during a graduating ceremony, not of him, it's just a random one. So I was arrested knowing when I went to court I could cite the 14th Amendment as my defense and eventually take it to the Supreme Court.
Wow.
So that is his racism.
So it seems like he wasn't terribly prepared to take it to the Supreme Court.
Well, I think one thing he didn't think about was when he returned to Penn State law, he basically got suspended. So obviously he thought he was going to still be a law student and could learn his way to defend this in Supreme Court, and he ended up getting suspended instead, so he doesn't have the full access anymore, I guess, to fully take it to the Supreme Court, knowledge-wise.
All right, so what happened to this case? The case was filed actually back in September. That was what we were looking at, was his amended complaint from this year. That's why I was confused. It was actually filed last September in 2018. And it was immediately dismissed. He didn't file the proper informa pauperis paperwork, so it was denied. He was ordered to complete and file the proper form, providing the details necessary to clarify the issues noted. Alternately, he may proceed by paying the fee within 30 days. He is reminded that he must sign the affidavit of poverty under penalty of perjury. If he fails to comply with this order, his case will be dismissed without prejudice for failure to prosecute without further notice. And that was signed by Judge Tim Savage. So then, instead of properly filling out the informa pauperis paperwork, he files a notice of appeal, doesn't pay the appeal fee, that gets terminated. And then he seems to just be going on currently going on a tirade, filing multiple lawsuits over this, all of which are getting dismissed one after the other. So one of the next things he does is he files against the University of Pennsylvania. I believe that's his law school. Then he files again against his judge, Tim Savage. Then he files against the Pennsylvania State System of Higher Education. Then he files against Jagex for Runescape. And then he also files one against Tinder. So I think we can probably go over this in more than one video, but let's just also sort of do a little bonus here and take a look at the Tinder stuff as well.
Just very quickly, the University of Pennsylvania was not his university. It's one of the university he visited. He used a charger there, and apparently one of the buttons was broken, and he was forced to do a survey, and that invaded his privacy.
Here is the golf club apartments dismissal. Then he goes on to file this notice of appeal against his judge, and he never pays the appeal fee there. The complaint against Tinder, Judge Tucker grants leave to proceed in forma pauperis, which means to proceed without paying the fees, allows the complaint to be filed and then immediately dismisses it. And then here's the memorandum the judge wrote. We're going to read two of these. Here's the Tinder memorandum, and then we're also going to read the Pennsylvania State Higher Education one. So the Tinder memorandum was just filed in July 16th. Plaintiff Amro Elansari, a litigant who is representing himself, filed this purported class action against Tinder based on allegations of fraud. He filed a motion for leave to proceed in forma pauperis. For the reasons below, the court will grant the IFP but dismiss the complaint. Elansari's complaint is brief. He alleges that Tinder, the dating application, sends you notifications saying 7 people like you. Subscribe for $15 to see who. Find out. However, Elansari suggests that the notifications are all fake, 3,000 miles away. He indicates that the events giving rise to his claims occurred in January through July of 2018, and in April and May of 2019, he seeks relief in the amount of $15 per month and punitive damages for each class member. The court will grant him leave to proceed in forma pauperis. It appears he is not capable of paying the fees. Accordingly, his complaint is subject to 28 U.S.C. 1915, which requires the court to dismiss a complaint if it fails to state a claim. This gives the court a special right to examine the claims and dismiss the thing right away, instead of allowing it to continue if it seems frivolous. Whether a complaint fails to state a claim is governed by the same standards as a motion to dismiss. So it's basically an automatic discretionary motion to dismiss, or automatically puts a motion to dismiss within the discretion of the court. The motion to dismiss requires the court to determine whether the complaint contains sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Mere conclusory statements do not suffice. Furthermore, if the court determines at any time that it lacks subject matter jurisdiction, it must dismiss. As Elansari is proceeding pro se, the court will construe his allegations liberally or broadly, so they're going to be very favorable to him. The court understands Elansari is bringing this case pursuant to a Class Action Fairness Act. However, although an individual may represent him or herself pro se, a non-attorney may not represent other parties in federal court. Accordingly, Elansari, a pro se litigant who is not an attorney, may not proceed with this case as a class action because he may not represent the interests of other litigants. To the extent that Elansari brings a fraud claim against Tinder in his own right under Pennsylvania law, he has not established a basis for subject matter jurisdiction over that claim. So, in other words, fraud is a Pennsylvania law. Every state will have their own fraud law. They're probably not all that different from one another. They all probably pretty much follow the elements of common law fraud. But it is a state claim. It is not a federal claim. So you can't just file a lawsuit in federal court and expect the federal government to adjudicate your state claim. When there are state courts for that, maybe the state court would be a little bit offended if the federal court just took all the litigation away because I can just choose to file in state court or federal court. They are not supposed to be competitions. They are not operating in competition with one another. The only independent basis for jurisdiction over a claim is the diversity jurisdiction, which allows a matter in controversy to exceed a sum or value of $75,000 and is between citizens of different states. This means that unless there is some other basis for jurisdiction, no plaintiff may be a citizen of the same state. As a general rule, it is determined from the good faith allegations appearing on the face of the complaint. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. Elansari alleges that he is a citizen of Pennsylvania and that Tinder is a citizen of Texas, which indicates the parties are completely diverse. However, the amount in controversy requirement is not met. Liberally construing the complaint, the court understands Elansari to be claiming that he subscribed to Tinder during the months of January through July 2018 and April through May of 2019. At a rate to $15 per month, Elansari's damages for those 9 months would be $135. If Elansari were entitled to an award of punitive damages, it is clear, to a legal certainty, that the amount in controversy does not exceed the jurisdictional threshold of $75,000 and 1 penny. Yes. The wording is that it must exceed $75,000, so there are no half pennies. So you can only exceed $75,000 by 1 whole penny. So technically, $75,001 is enough to get into diversity jurisdiction, not $75,000 even. I said dollar. I meant penny. $75,001 penny.
But you guys don't use pennies.
Well, I mean, we have pennies.
We use pennies.
Do you? I thought that was a British thing.
No, Canada.
It's Canada. We ditched
Oh,
it.
yeah. Pennies, yeah, we have pennies. They're the little copper ones, the little golden, whatever, round ones.
For the foregoing reasons, the court will grant Elansari the leave to proceed in formal pauperis and dismiss his complaint without prejudice. He will not be given leave to file an amended complaint because he cannot cure the defects discussed in this memorandum. However, Elansari may refile his claims against Tinder in state court. Additionally, if Elansari retains counsel, he may refile his class action through counsel in this court by filing a new case. An appropriate order follows. So if he got an attorney, he could probably file his class action. I don't know that any attorney is going to want to work with him after they see all of this. But, okay, so that happened. And then, just to sort of continue, we'll do one more 4-page dismissal of an Amro Elansari complaint. Plaintiff Amro Elansari filed this litigation against the PA state system of higher education and 2 attorneys, Michael Ferguson and Jill Fluke. He also filed for IFP in formal pauperis, and the court will dismiss his claims for lack of subject matter jurisdiction and for failure to state a claim. Elansari's complaint is brief and unclear. It is mostly comprised of sentence fragments. Elansari appears to be asserting a claim for fraud and patent infringement. His claims are based on the following allegations. 1. fraud taking place within PASA while receiving federal funding, arrow, students cheating to pass, and 2, he invented patent pending system and told the defendants, who allegedly replied that they are not obliged to respect his patent. As a relief, Elansari seeks whatever the jury decides, and accountability. I want to like dress up as Charlie Day or Charlie Kelly from Always Sunny in Philadelphia.
Can't read these words. They're not in the right order. I think you might be dyslexic, bro. Hello, fellow American. This you should vote. Me. I leave power. Good. Thank you. Thank you.
Seriously, is that not exactly how Charlie would write a complaint? Let's see. Fraud taking place within PASA while receiving federal funding. Arrow, students cheating to pass. And I invented patent pending system. I'll take whatever the jury decides. And accountability. Are you kidding me?
Bird law.
Bird law.
Oh.
The court will grant Elansari leave to proceed in forma pauperis because it appears that he is not capable of paying the fees. We just saw that. Accordingly, Elansari's complaint is subject to Section 915, which requires the court to dismiss, and we went through all of that. This court has noted that Rule 8 requires that pleadings provide enough information to put a defendant on sufficient notice to prepare their defense, and also ensure that the court is sufficiently informed to determine the issue. Discussion. The only federal claim Elansari appears to be raising is a claim for patent infringement. However, his sparse factual allegations do not support such a claim. To state a patent infringement claim, a plaintiff must allege the following minimal requirements. 1. An allegation of jurisdiction. 2. A statement that plaintiff owns a patent. 3. A statement that defendant has been infringing on the patent by making, selling, using the device embodying the patent. 4. A statement that the plaintiff has given the defendant notice of its infringement. And 5. Demand for an injunction and damages. Elansari has not identified a patent that he owns, and even if we assume he owns a patent, he has not described how any of the defendants are infringing said patent. Accordingly, the complaint fails to state a patent infringement claim. The only other claim Elansari appears to be bringing is for fraud under state law. The only independent basis for jurisdiction is, diversity jurisdiction, where the matter in controversy must exceed the sum or value of $75,000 exclusive of interest and cost, and is between citizens of different states. It requires complete diversity between all plaintiffs and all defendants. That means unless there is some other basis for jurisdiction, no plaintiff may be a citizen of the same state. Here, the complaint suggests that Elansari and the defendants are all citizens of Pennsylvania. It is also not clear whether the amount in controversy exceeds $75,000. Accordingly, there is no basis for subject matter jurisdiction over Elansari's fraud claim. For the foregoing reasons, the court will grant Elansari leave to proceed in forma pauperis and dismiss his complaint. This dismissal will be without prejudice, so he has the right to file an amended complaint in the event that he does figure out how to state a claim for relief. An appropriate order follows. What do you think of that? So, yeah, that is essentially a real-life Charlie Kelly.
I do feel for him in a way. Like, he clearly is passionate about a lot of things. It's just too bad that the moment he got in law school, he got excited about all the lawyery terms and decided he was an expert instead of putting his head down for, what, 4 years, is it?
Yeah, so
get the expertise how to actually write these things and how the law properly applies to it. Because, I mean, he does seem to have the passion to maybe...
Well, that's one of the things that we would that a board of law examiners would evaluate someone's ability to conform themselves to the rule of law. And it seems like Amro Elansari is a very passionate individual, as you said, would make a great advocate otherwise, but he is unable to conform himself to the rules of law. And so therefore he would be unable to help others achieve desirable outcomes within the boundaries, within the spectrum of possible outcomes. He would be unable to help them conform themselves to law. Now, let me be clear. You don't necessarily have to agree with the law, but if your lawyer is telling you, look, this is how the law plays out, you need to be able to follow that. Vice versa, imagine if the lawyer is the one who's unable to follow the law and create then an unbiased understanding of it. So even if I may disagree with a law, I at least have to know the consequences, be able to explain them in an unbiased fashion to my clients, make a recommendation that is in my client's best interest, not my best interest, because I'm a fiduciary.
I would fear for him a little bit in law school because writing is such a big component of law. If you can't concisely and clearly communicate your ideas, you're going to get your butt kicked.
But at the same time, there's normally good back-to-school sales to buy a whole set of Sharpies. I got like 48 of them last year for a tenner. That could help it for a year.
Oh, you get him a whole bunch of Sharpies.
In every color he desires.
We're not going to go over anything more. We will look at more and see if it's worthy of another video. So if you enjoyed this video, definitely let us know that we should make another one, because there's more of Amro Elansari. Maybe he'll see this video and he'll start to understand that it wasn't his passion that got these cases dismissed. It was his inability to conform himself to very basic rules of law, and very likely not discrimination from all of those people. Certainly I could understand a discrimination claim, that there's lots of discrimination in this world, but it seemed like an awful lot of people. And when you do all the sort of probability math in your head, it would be a extraordinarily low chance that every single one of those individuals was conspiring to make Amro Elansari, treat him differently than other people. I don't think so. Well, thank you for joining us, everybody. That's our show. I am Leonard French, your favorite copyright attorney. Joining me in the studio here is Kaylee, and in the virtual studio has been Tactical and Brandon. Thank you to our Patreon and sponsor supporters. We thank you for being part of that budget and helping us produce these now daily shows, dropped every day at 7 a.m. And sometimes we do have a second one as well. So thank you very much to our patreon.com/ljfrench and sponsus.org/law supporters at the $500 level in the month of July. Thank you very much to Joshua Davis from TandaPay. We'll be doing a video for Joshua probably in the next week or two. Thank you to the $50 plus supporters: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me. There are more supporters you can support for as little as $1 a month, and that gets you access to our supporter Discord channel, as well as occasional behind-the-scenes posts and things, and an every Sunday half-an-hour live stream just for the supporters, just sort of a pre-production show for us to hang out. We do plan on expanding some of that to include a weekly supporter live stream, like question and answer kind of thing, where again it would only be $1 a month to subscribe to that. So thank you very much for joining us. I'm going to let you guys go. Have a wonderful week, and we'll see you in the videos that drop. See you on Sunday at 10 a.m. right back here on twitch.tv/lawfulmasses for the live Sunday show. I'm Leonard French, your favorite copyright attorney. Have a great week. Love you. Bye.